Labor relations often deals with collective bargaining and contract negotiations, but it also incorporates other strategic human resources methods and procedures that influence unions and non-union employees. When done well, labor relations can help build a compliant and beneficial relationship between management and labor. When labor relations break down, it could result in a walkout, a work slowdown, or conflict. Labor relations are a critical component of a successful business strategy, particularly when dealing with a unionized workforce. As a leader, it is important to understand what a union is and how to effectively maintain a positive working relationship. Labor relations refer to the formal interactions and legal relationship between company management and a unionized workforce. It centers on collective bargaining, negotiating employment contracts, managing workplace grievances, and complying with labor laws. Before getting into the details of labor relations, first you must understand what a union and a collective bargaining unit is. A union is an organization of workers formed for the purpose of advancing its members' interests in respect to wages, benefits, and working conditions, and it is also a big business. A bargaining unit is a group of employees with common interests who are represented by a labor union in their dealings with management. The primary labor law agency within the United States is the National Labor Relations Board, or NLRB. The National Labor Relations Board forbids discrimination against employees who join unions, exercise leadership, or engage in strikes. Any unfair labor practices, or ULP, are filed with the National Labor Relations Board, who will conduct an investigation to determine their validity. Generally, the result of unfair labor practices will be to issue a complaint, defer to arbitration, or dismiss the charge. A collective bargaining agreement, or CBA, is an agreement, in writing, between an employer and a union setting forth the terms and conditions of employment and usually containing provisions in regard to rates of pay, benefits, work, or other working conditions of employees. A collective bargaining agreement is not a contract of employment. Employees are hired separately and individually. However, the tenure and terms of their employment once in the unit are regulated by the provisions of the collective bargaining agreement. A collective bargaining agreement outlines the various conditions of employment mutually agreed to by the union and management. The agreement is a binding document on employees, the union, and management. It is in everyone's best interest to assure that the terms of the agreement are abided by and that disputes over the application and meaning of the agreement are resolved quickly and at the lowest level possible. Once a union is recognized as the exclusive representative of a bargaining unit, management may not deal with any other organization concerning its employees over matters that are within the purview of labor law. The term exclusive representative refers to a status accorded to a union approved by the National Labor Relations Board. The recognized union is entitled to act for and negotiate collective bargaining agreements covering all employees in the bargaining unit without discrimination and without regard to labor organization membership. In dealing with the union, it is important to remember that the union is not your enemy. Contrary to some personal beliefs and the adversarial atmosphere that may have been created during contract negotiations, the union can be a very useful ally when it comes to dealing with day-to-day problems. Consider the following. No one likes surprises. Bring the local union official in to discuss policy and procedural changes that are being contemplated, directives from the client, as well as disciplinary issues before the fact. Solicit their input before making a tough decision, when appropriate. Arrange a time to sit with the local union official on a regular basis. Do not always discuss negative issues. Do not be afraid to let the union take credit for a change that benefits us. They must be viewed by the membership as doing something. Also, the union is not your friend. The role of the local union official is to enforce the terms and conditions of the contract, as well as represent its members. Legally, they can be sued for failure to represent as well as be the subject of an unfair labor practice charge. Do not expect a personal relationship and do not take it personally if they do not agree with you. Remember, they have a job to do. Administration of the collective bargaining agreement is a daily function and quite often are one of the most important responsibilities managers and supervisors have. It is their interpretation and application that ensures compliance with the terms, establishes past practices, and can be the cause of employee grievances. Managers and supervisors are not the only people administering the contract. Union officials and employees also keep a keen eye out for assuring the contract is being complied with. Contract administration and interpretation can be a difficult task. Management must ensure that every supervisor has a copy of the collective bargaining agreement. The collective bargaining agreement must read thoroughly, questions should be asked to clarify, and refer to it often. Some language may be ambiguous, oftentimes on purpose. There may be conflicts between the various provisions of the agreement, and laws may change during the life of the agreement. None of this makes the task any easier. When disputes arise concerning the interpretation of the contract, both parties have a number of venues in which to seek resolution. For example, interpretation of the agreement means figuring out what the written rules negotiated between an employer and a labor union mean and how to apply them to real workplace situations. Governed by the National Labor Relations Board framework, this process uses standard contract principles alongside unique labor law rules to resolve disputes over pay, hours, and duties. Past practices is a long-standing, unwritten work habit or rule that both the union and management accept over time. If a collective bargaining agreement, CBA, is unclear or silent on an issue, a valid past practice can act like a binding part of the contract and be enforced through a grievance. Negotiation history helps resolve disagreements over a collective bargaining agreement by looking at past talks, shared notes, and previous language proposals. Both sides use this record to prove what they meant when they wrote a disputed rule. And disagreement resolution. When a dispute arises over the meaning or rule of a collective bargaining agreement, resolution options typically follow a structured path. These options include internal multi-step grievance procedures, outside mediation, binding arbitration, and legal action through the National Labor Relations Board. An important process in contract administration is to maintain an open dialogue and communication with local union leadership. Develop a positive relationship with the local union built on trust, respect, and cooperation. While this can be a challenge in many situations, a good relationship can help solve problems informally and keep little issues from becoming big problems. Deal in good faith with the union. Keep an open mind when issues arise. Management is not always right. So, what are grievances, mediation, and arbitration? A grievance is a formal, written complaint raised by an employee who feels their employer has treated them unfairly or broken a rule. It usually involves a violation of an employment contract, labor laws, workplace policies, or safety standards. Labor mediation is a voluntary, confidential process where a neutral third party helps employers and employees or unions resolve workplace conflicts, contract disputes, or bargaining impasses. The mediator does not make final decisions or force a settlement, but guides both sides toward a shared agreement. An arbitrage is the business practice of shifting jobs or outsourcing tasks from high-cost labor markets to lower-cost regions to reduce overall expenses. Companies capitalize on geographic wage gaps by hiring equivalent skills overseas or in cheaper domestic regions for a fraction of local costs. The initial phase when there is an issue with an employee who is part of the collective bargaining unit is to counsel. The purpose of counseling, as simply stated from a disciplinary and poor performance perspective, is to compel a change in an employee's unacceptable behavior and/or performance. It is important to remember that if it is not in writing, it did not happen. The counseling objectives include to reinforce corporate policies and/or procedures, to prevent unacceptable behavior or performance of employees, to correct unacceptable behavior or performance of employees, and initiate progressive discipline when appropriate. The outcome of the counseling session should be resolving the issue and prevent recurrence. Any performance and/or behavioral issues should be brought to the attention of the affected employee in a timely manner. Be specific when addressing the problem. Discuss exactly what the problem is. Introduce ways the problem can be remedied. Provide both positive and negative feedback. Discuss the consequences of not correcting the problem. And maintain communication and follow-up with the employee. It is important to let the affected employee know early on what the consequences are should they choose to continue the unacceptable performance and/or behavior. And again, it must be documented. All counseling, even verbal, must be documented. Effective employee labor counseling documentation requires recording the employee and supervisor names, specific dates of incidents, clear descriptions of performance or behavior issues tied to company policy, agreed upon corrective action plans with deadlines, and signatures from both parties. It is recommended to note on all counselings or other forms of written notification the following final chance warning. Any future acts of misconduct and/or violations of policies, procedures, or regulations will result in the imposition of additional disciplinary action, up to and including termination of employment. Historically, arbitrators take a favorable view when such a warning has been issued and the employee continues to perform poorly and/or continues to perform in acts of misconduct. This approach is a true final chance. But, you must be willing to follow through with the final action should the desired change not materialize. Do not say it if you do not mean it. In determining disciplinary action, management should consider. Disciplinary action requires a precipitating event that is a violation of documented company policy. Management should not unreasonably delay the imposition of disciplinary action. Document, in great detail, all reasons for disciplinary action. Ensure, beyond a reasonable doubt, the employee committed the infraction. Ensure the employee was aware, or reasonably aware, of the specific rule or policy. Identify what written and/or verbal communications were given to the employee. Identify previous discussions and/or notices that were given to the employees. Identify if the employee acknowledged his or her understanding of the rule or policy. Thoroughly investigate and document, in detail, the reasons for disciplinary action. Assume the union will do likewise. Obtain detailed witness statements. Ask questions to clarify vague points. Make sure the employee committed the infraction. Make sure the employee was aware, or should have been reasonably aware, of the specific policy or rule. Is there an acknowledgement of the employee's understanding of the rule or policy violated? If not, it should be a consideration to do now for future instances. Document, document, document. If it isn't documented, it never happened. Consider previous discipline, warnings, counseling, etc., that were given to the employee. The degree of discipline should be appropriate to the seriousness of the offense. Discipline is intended to be corrective, not punitive. Keep the union leadership up to date. They are going to find out anyway, so be upfront. And a basic principle that arbitrators apply when reviewing employee discipline is the just cause standard. Just cause is a standard protection in union contracts requiring employers to have a fair, proven, and reasonable basis before punishing or firing a worker. Just cause has become a common standard in labor arbitration and is included in labor union contracts as a form of job security. Typically, an employer must prove just cause before an arbitrator in order to sustain an employee's termination, suspension, or other discipline. Usually, the employer has the burden of proof in discharge cases or if the employee is in the wrong. In the workplace, just cause is a burden of proof or standard that an employer must meet to justify discipline or discharge. Just cause usually refers to a violation of a company policy or rule. In some cases, an employee may commit an act that is not specifically addressed within the employer's policies but one of which the employer believes warrants discipline or discharge. In such instances, the employer must be confident that they can defend their decision. When an arbitrator looks at a discipline dispute, the arbitrator first asks whether the employee's wrongdoing has been proven by the employer, and then asks whether the method of discipline should be upheld or modified. In 1966, an arbitrator, Professor Carol Dougherty, expanded these principles into 7 tests for just cause. The concepts encompassed within his 7 tests are still frequently used by arbitrators when deciding discipline cases. Dougherty's 7 tests are as follows. Notice. Did the worker get a clear warning about the rule and consequences? Reasonable rule. Is the rule tied to safe, efficient work? Investigation. Did management check the facts before acting? Fair investigation. Was the check objective and unbiased? Proof. Is there solid evidence the worker broke the rule? Equal treatment. Are all workers treated the same for the same act? And penalty fit. Does the punishment match the offense and past record? If appropriate, use progressive discipline. Progressive discipline is a step-by-step workplace process used by employers to correct an employee's poor performance or bad behavior. Penalties grow worse over time if problems continue. It usually starts with a verbal warning and can end in firing if no changes happen. In general, progressive discipline is based on the premise that penalties short of termination allow employees a chance to correct problematic behavior and remain productive employees. This is a sound way of administering discipline that demonstrates management attempted to compel a change in the unacceptable performance and/or behavior, with the desired effect not transpiring. Keep in mind that the use of progressive discipline may not be appropriate in all situations. The burden of proof will always be with the employer. Make sure all disciplinary decisions are based on fact, not maybe. Weingarten rights guarantee unionized employees the right to have a union representative or steward present during any investigatory interview with management that the employee reasonably believes could lead to discipline. Established by the U.S. Supreme Court in 1975, these rights must be actively requested by the employee. The National Labor Relations Board has established 3 conditions that must be met for a meeting to be considered a Weingarten meeting. Weingarten rights apply for investigatory meetings. A meeting falls under Weingarten rights if the employer is asking questions to gather information, investigate alleged misconduct, or evaluate work performance that may trigger discipline. Reasonable belief. Additionally, Weingarten rights apply if the worker genuinely believes that the discussion could result in a reprimand, suspension, demotion, or termination. And exclusions. Weingarten rights do not apply to routine work instructions, training, or meetings where management is only handing down a final, pre-decided disciplinary action without asking questions. The considerations for granting an employee's request to evoke their Weingarten rights include: first, they do not start until the interview begins. A covered employee must clearly ask for your representative. Management is not legally required to offer a union steward automatically. The right includes only the ability to have a union representative, including a steward, elected or appointed official, if possible, to be present. If the employee requests a particular union representative, allow that representative to be present if immediately available. If no union representative is immediately available, allow one to be called in as long as the representative is in the immediate area and is expected to arrive as soon as possible, usually within 30 minutes. Whenever possible, schedule the interview with the employee when a union representative is available. And document the meeting in detail. Leaders must know the difference between what is and is not a grievance. Quite often, grievances are really just gripes. A grievance must involve interpretation or potential violation of the collective bargaining agreement. Do not take a grievance personally. The union has a duty of fair representation and in some cases will pursue a grievance as a matter of self-preservation. Process all grievances in accordance with the terms of the collective bargaining agreement. Some considerations include: was the grievance filed timely? Respect the timelines for response. Insist the union do likewise for submission and appeals of unsatisfactory responses. Should the union submit a grievance that is outside the timelines, reject it. Do not accept from the onset. Remember, if you accept one grievance or appeal that is untimely, the union may view that as a precedent and you will have to live with it going forward. How and when should management respond? Again, consistency is key because past practices will be used against you when deviations occur. Who should be at the grievance meeting? A standard workplace grievance meeting requires the employee raising the complaint, an impartial chairperson, usually a manager not involved in the core issue, a human resources representative, and a neutral note-taker. The employee also has a right to bring an eligible support person, such as a work colleague or union representative. Additional grievance hearing considerations are: who goes first in case presentation? Generally, for contract issue the union should go first, and for discipline hearings the company should give the initial presentation. Give the union reasonable latitude in presenting their case, but do not permit them to take an excessive amount of time or demean management. Treat the union representative as an equal. Allow for a robust debate of the issue but stay calm. And require the union to identify the specific contractual provision allegedly violated upfront, for without a violation there is no grievance. Addressing minor frustrations before they grow stops most complaints from turning into official disputes. Here are some ways to prevent grievances from being filed in the first place. Encourage open dialogue. Let staff share worries safely during regular chats. Train leaders. Teach managers how to listen well and stay neutral. Fix issues quickly. Solve small problems before they get worse. And be fair and clear. Use clear rules and apply them the same way for everyone. And here are some daily best practices for management to follow in working with a unionized workforce. Listen actively. Pay close attention when team members speak. Keep records. Write down performance expectations and review notes. Act calmly. Never make major choices when you feel angry or annoyed. And use mediation. Offer neutral help to settle disputes early. Additional pointers for dealing with the union include: when an employee is serving in their union role or capacity, they are afforded a certain leniency in both language and behavior. You do not have to tolerate abusive language, swearing or cussing that is offensive, or verbal abuse directed at you other members of management. Remind the union that you expect a certain level of decorum and are personally offended by either their language or conduct. Bear in mind, if you engage in similar conduct, it will be difficult to object to the same from the union. And outside of this environment, you set the rules that are to be followed in the workplace. Labor relations often deals with collective bargaining and contract negotiations, but it also incorporates other strategic human resources methods and procedures that influence unions and non-union employees. When done well, labor relations can help build a compliant and beneficial relationship between management and labor. When labor relations break down, it could result in a walkout, a work slowdown, or conflict. Labor relations are a critical component of a successful business strategy, particularly when dealing with a unionized workforce. As a leader, it is important to understand what a union is and how to effectively maintain a positive working relationship. We hope you found this training video valuable. Please give us a like and click the subscribe button to access additional FSTG training videos.